All right. So my name is Melissa Nichols. I'm the Community Awareness and Opportunities Director at Riverside. And we really appreciate you guys making time to visit with us tonight and learn a little bit more about guardianship. This is our third of 4 sessions that we offer throughout the year. And Laura Drake is our guest speaker who has been doing this for many years for us. I am going to moderate the group for our session tonight. And I'm going to mute everybody if that is okay, just to make sure that we're all able to hear Laura as she presents to us. So feel free throughout the session, if you have a question, you can either raise your hand with that feature or type a question in the chat box. I'll be keeping an eye on that so that we can pose the questions to Laura either during the session or at the end if we've got time for questions and answers. And without further ado, I am going to turn it over to Laura Drake from the Community Fund Management Foundation.
Hello, everybody. I have to start off by telling you about my necklace. So I have this peacock necklace tonight. So I always have jewelry and I never wear it. I teach at a college and I thought it would be fun this semester for each class to wear a different necklace and see if the students ever noticed. And I have a lot of like nighttime necklaces, like, you know, very blingy, way more blingy than this. And I have worn some so very inappropriate for 9 a.m. necklaces and they have not said a word yet. So this is my fall semester project to see if they ever say anything about the necklaces. I've decided it's going to be an extra credit assignment on the final exam. What was different each day? And if anybody in the class gets it, they all get extra credit because it's silly. So I have to keep the necklace on because I haven't taken the photo to document this necklace yet. I have to, that's my reminder every time I take a photo and I post them on Facebook. So everyone, because they're very blingy, it's a lot of fun. So I'm an attorney and I live in Cincinnati and I work for Community Fund Ohio, which is a special needs trust organization. And in that vein, that's how I would oftentimes be invited to speak at these kinds of events. And I'm talking tonight about guardianship and really I want to be talking about alternatives to guardianship. And I can move this, here we go. And I have some lovely dogs here with me tonight. And they're gonna bark and I can tell that right now. I'm really, I've been doing a lot of things to make it so it doesn't seem like they should bark, but they're going. So I apologize. Here we go. It worked. I shut all my blinds. That's why there are no blinds behind me. So you guys should be able to see my screen now, right? Cool, perfect. All right, so we're going to talk about not just guardianship because that's, I think for a while there was a real push to encourage everyone to get guardianship over their children with disabilities. And it was all about HIPAA. When HIPAA came into play, hospitals and doctors said, you have to get guardianship or we can't talk to you about your child anymore. There's a real, obviously, I've never thought that made any sense. But now there's something called supported decision-making, which is a new concept also, and we're going to slightly address that. They're a little bit more touchy-feely than I am even, but the idea is that, you know, guardianship is about making decisions, and so the idea is to make sure that the individual can make the decisions themselves when possible. So you are automatically your child's guardian if they're under the age of 18. What we're talking about, if you're their parent, you could also become guardianship as a grandparent or something like that, and that might also require court assistance, but that all ends when someone turns 18. To be a guardian after the age of 18, you have to, even if you had a guardianship of your minor grandchild, the minute they turn 18, you would have to reapply to be a guardian after someone's 18, all right? So, because we presume someone is competent until the probate court determines otherwise. When you become guardian for a child under the 18, it's not about competency, it's about who's going to make the decisions. So, when do you need a guardian? Well, if a probate court has said the person is incompetent, then you're going to need a guardian. Or there's a need which can't be met otherwise. All right, which means that there's a decision that has to be made that the individual cannot make. So I might just be unconscious and need non-emergency surgery, but they think I'm going to wake up soon, but they need someone to consent. Well, that's a present need for a guardian. All right, right? That's an emergency, temporary medical guardianship. We're not talking about that here. We're talking about the finding that someone is incompetent. The person who's going to have the guardianship over them, they're called the ward. All right, we don't call them wards of the state. We try not to use that anymore. They're just the ward. So the guardian is the individual who applies to gain control over the ward, to make decisions on behalf of the ward. Like I said, a lot of people have been told that the reason they should seek guardianship is that it's really for the safety of their own child, right? And they want to be able to access information because they want to help sure that they make good decisions. And then also just to apply for services. There's also an aspect about handling money. And I think a lot of people come to the belief that guardianship is the only option that they have when they have a child with a disability. But you need to understand that a guardianship is a determination, is a decision by a court that says that the ward, that person cannot take care of their own needs. It removes almost all decision-making authority from that person. And it gives all that responsibility to somebody else. Now, whoever's the guardian works at the pleasure of the court. So oftentimes, even the guardian has to go to the court to get approval of things. But the ward doesn't really have many rights. They've been limited. Their rights have been pushed over to the guardian. And this is the most important thing. Now, in my example, where I am unconscious and somebody needs to authorize some surgery and they think I'm going to wake up, that was a limited temporary guardianship. That guardianship is going to expire at a set date or when I'm better or whatever. It's usually going to be it'll only be good for 30 days, then it's over. But a regular guardianship that parents go through, once it's been created, because you're going to court and saying, hey, my child is incompetent. And then to get it removed, you have to show they're competent now. There's been a change in circumstance that has made them able to make their decisions. My example, I was just unconscious. I had a bad concussion. 30 days later, I'm healthy. So that's gone. But generally speaking, it's very hard to say they had Down syndrome. Yes, they were very capable of making some decisions, but not all. I have guardianship. Now their Down syndrome is better. That doesn't make any sense. That's not going to usually work. So not all rights are taken away. Not your fundamental rights, like you still have the right to vote. But oftentimes we see it used to overprotect or control people. So, and we see sometimes it is a way to use to obtain information that you would otherwise be shut out of without a document. And that's what I really want to point out. We're talking a little bit about guardianship, but I want you to remember there are alternatives to guardianship. We'll get to those in a second. So HIPAA has been presented as this, hey, my child turned 18. They won't talk to me about their health decisions anymore because the HIPAA. And, but the reality of it is that the child, your child or your family member can say, hey, I want my mom in the room. It does not have to be in writing. They can just state that. And then, and that's all you have to do. And then you can be in the room. We have a problem when we have nonverbal children, but still your child can say that you want to be present. It does not have to be in writing. Now that's just going to be one at a time, one and done situation. But each time you go to the doctor's appointment, if your child agrees that you can stay there, you can stay there, or another family member. But the reality of it is the reason we want to avoid guardianship is that you and I, as adults, we learn that the more decisions we make, the easier it is to make new decisions, right? We make a decision, we suffer or we benefit from the consequences, and that directs us in how to make decisions going forward. Well, that's true for everyone. And so if we take away the ability for someone to make a decision, then they will not learn that skill. And that's really important. I have a friend whose parents were very controlling, and I hope he never watches this. And they made up most of his decisions for him. And to this day, he's 50 years old, and they've passed away. And he has a hard time. He's an adult. He's a very successful individual, but he cannot make decisions well. He obsesses over them for weeks on end because it was not a skill his parents put into him. They controlled his life until he was well into his 30s, and about the decisions that he would make. And so he doesn't have that skill. That's true for everyone. That's also a skill that an individual with an intellectual disability can also learn. But if they are taught the benefits, the risks and benefits of those decisions, they can help make them in their own life. And that's why if you take away that skill, it's less likely they'll be able to make them in the future, which also makes it less likely that you could ever remove a guardianship. So let's talk about the least restrictive type of support, all right? What's the least restrictive, an alternative to guardianship is what's the least restrictive type of support. And that's what you want to focus on before you go to guardianship. So if I'm worried about handling my child's finances, for the record, you never want to do guardianship of the estate, which is the financial one, unless you have no choice. But if I want to make sure that their SSI payment is protected, I can become the representative payee with Social Security. I just go to Social Security and I become the representative payee. Now I have to apply for that, but if my child goes with me, that's pretty easy to get done. You can also do it by the phone now. It's not so bad. I can become an authorized representative. So Alice, you had a question that you wanted to ask? Nope. If you'll type it in, then if you can type it into the thing also, Melissa can read it to me or let me know. Or you can unmute yourself and ask. So an authorized representative, there are different organizations that allow that. So DD Services has an authorized representative form. So does the public school system. So these are forms that you can use, but also with trust and banking, you can become an authorized representative. Sorry. And then if there's enough money, you can place it into a trust and then the trustee controls it. You can become a financial power of attorney. So if you're worried that your child's going to open a credit card and you won't be able to talk to the credit card company, or if your child has a credit card and you want to be able to talk to the credit card company, you can become the financial power of attorney. And you can go to proseniors.org and get a free financial power of attorney form that you download. It will need to be signed before a notary, but you can prepare the document without hiring an attorney. If they're working and you want to make sure that you know where the money's going, you can set up a direct deposit of their paycheck, and you can have that as a joint account. Or if you have that power of attorney, you can be on the account as the power of attorney. When you have payments, if you have to have a service provider and you're worried about writing checks, if you've set up a bank account, then you can set up direct payments to the service provider. Almost everyone will do that. Like Fifth Third Bank, they have a bill paying service. So your child doesn't have to sign the check, it's automatically taken care of. So these are all ways you don't need to get guardianship of the person, because there are other options that guardianship of the estate, because there are other options that you can use. For personal decision-making, that's where we get guardianship of the person, right? The other one was guardianship of the estate, the financial estate. This is guardianship of the person. There are other options also. So you can get a healthcare power of attorney. You can actually also go to proseniors.org for this. I don't know why this link worked and the other one didn't, but you can also go, and ProSeniors has a healthcare power of attorney, and so does Hospice of Cincinnati. They both have free healthcare power of attorneys that you can download. And now these do not need to be notarized. You just need to, you can either have them notarized or have two witnesses. It's one or the other. So that's a lot even easier to do. If your adult child, they are adults, they're over 18, but if they're involved with people that you think are dangerous for them or taking advantage of them, you can contact Adult Protective Services. And that's a mechanism that you can put into place to protect your child if someone inappropriate is around them. If they agree that the person is not appropriate, then you can get a protection order. You can't do, if your child loves Johnny and Johnny thinks Johnny's so much fun and you think Johnny is a daredevil nightmare and you don't want Johnny anywhere near your child, you're not going to be able to get a protective order because your child also has to state that they feel threatened or worried by the person. But if your adult child is worried about Johnny also and thinks Johnny's kind of scary, then you can get a protective order. You can also just have a good circle of support that help in the decision making. Now, there's been a lot about conservatorship in the news lately, thanks to Britney Spears. In California, conservatorship is guardianship. There's no distinction of these things. Ohio does distinguish it. A conservatorship is kind of an assistant who helps you provide care assistance. It's much easier to terminate and it's voluntary. The individual who's the ward agrees to it. They call it that in California, but that's actually guardianship there. So we have something called conservatorship, which is different. You can have a support broker and this chosen representative. That's what you have with DD services. And they can help you. And there's something just like that also with the public school systems. So even though your child has turned 18, you can still be the one who communicates with these agencies on behalf of your child. Your child does have to sign these documents or make their mark. So some people say, well, they can't sign their name. Yeah, but if they can make an X, there's a mechanism for that also. The trick is they have to understand that what they're doing. They have to understand that they're allowing their parent to make whoever they're choosing to make decisions for them. And if they can express that they understand that, then they can sign these documents. So they don't have to be verbal. They don't have to be able to sign their name. They have to be able to show that they understand what they're signing. And that's the trick in those documents. Did you have a question, Alice, or? Okay, so when we talk about guardianship, there are many different types. So there's the limited guardianship. This is the least restrictive form of guardianship. It's just for medical or placement. So basically you could become, if you had an adult who needed to go into a facility but couldn't sign the paperwork or whatever, you could become the guardian for the limited purposes of placing them in that facility and then withdraw as guardian. We see that happen sometimes. But like I said, also it's that situation where kind of an emergency medical situation where you fall and you bump your head. Now emergency guardianships, I'm going to jump ahead to that. They're only good for 3 days. So they're kind of useless. They are truly for an emergency. And the doctor has to show up in court and testify that there's an emergency that needs their care. The person has to be taken under guardianship immediately. It's seriously, it's only good for 3 days. So, and then you got to come back and do the whole thing over again. So it's kind of annoying. It's not usually really worth it. But what we talk about generally are guardianship of the estate or person, or what's called plenary, which means both person and estate, a full guardianship. We usually call it a full guardianship in Ohio. As a general rule, we never recommend that you get guardianship of the estate unless the person has inherited a crap ton of money. And I mean a lot of money. It's got to be definitely over $15,000 before we even remotely care about guardianship. And even then, if they can spend it, spend some of it. Because the guardianships of the estate are very complicated. An interim guardianship is like an emergency, but it's for a short period of time. A guardian ad litem is one who's appointed by the court to protect the ward's interests. So it's when there's a dispute whether or not the guardianship is necessary. The court will basically appoint an attorney to be the guardian of the individual to represent their side, to represent their case in court. And then co-guardianships. Now, co-guardianships means that there are two guardians, which makes sense. And lots of times mom and dad want to do it together, and that's fine. Some courts don't like it. Some are fine with it. It just depends on the judge. What they will not have is if the guardians are coming into court and saying, I want this to happen and he wants that to happen, judge, you have to make a decision. The judge is going to make a decision. The decision is going to be that there's only one guardian going forward because the judge is not there to make all the decisions. That's the guardian's role. And if the two guardians can't agree, then they should not have a co-guardianship. So if you are going and asking the court for that, you need to make it clear that you speak as one voice and that you will work things out and you will understand what's going on. They especially get worried in situations with divorce. They get a little more freaked out about that. But if you can present to them that you're in agreement, it shouldn't be an issue. The other time we see co-guardianship is mom and dad have been guardian, then mom is, because dad's passed away. Now the oldest sibling or the youngest sibling is going to add on as the co-guardian, so they can kind of learn the rules, but still have mom be the primary sort of thing. And then mom goes away, and then the oldest sibling adds the youngest sibling or adds their child, a niece or nephew. So they're kind of spanning generations. I'm seeing a lot more of that, the co-guardianship, because they weren't really popular, but they become much more popular. So the courts are pretty okay with that because they recognize it's getting the new guardian up to speed before you take everything away from the former guardian who really doesn't necessarily, they're not there enough to do it anymore. So, so it used to be that to be the guardian of an adult, you had to be a resident of Ohio. That's just not true anymore, but it's still somewhat complicated. So nowadays, if you have a child with a disability, you can name somebody from another state to serve as guardian. So in your will or in your financial power of attorney, you can say, hey, if my child who's been disabled since birth needs a guardian, this is who I want it to be. And you can list 100 people. I once did one where we listed about 25 or 30 people because they had a really deep list. And especially around here, you know, we're on 75, but Indiana's not too far away, and Cincinnati, Kentucky's not too far away, and people move across borders, and they do that, and but also, you know, you're the guardian. You want one of your kids, your typical kids, to be guardian later on, but they've moved to Indianapolis or they've moved to Denver. If you have listed them in a legal document like the will or the financial power of attorney, they can become that guardian. But if you haven't, they will not be able to get guardianship of the person with any ease anymore. It's quite complicated. So you can, and again, I remember I told you we list about 20 or 30 names. You nominated them, and that's kind of in the order, the parents nominated them. Those people then have to go to court and apply to be guardian, and then the court appoints the one that they want. So if you nominated, you know, Joey, because Joey's been a good friend and always been there, and then Joey, well, by the time it rolls around, Joey's like, I can't handle this. Joey just doesn't apply. So it's not a problem. And then the court just moves on to the next one. So we might ask Joey to sign a thing saying, I can't do it. I think it'd be great if the next person on the list did it. But you've nominated these people. They still have to apply, and then the court is going to appoint them. So there's multiple steps in there. So that's why, go ahead, name 20, 30. What's the downside? If these people could potentially be your child's guardian, that's great. If they don't want to be, well then, you know, lesson learned. Now, this is also something that happens, like, I want to be guardian, but, you know, what if they steal a car, or what if they hit somebody? Well, you're their guardian, you're not them. So the only time you could ever personally be responsible for the acts or the debts of the ward is if you were told by the court that you had to create a less restrictive environment, like that they had to be taken someplace and you didn't take them. And even then, you'd be in contempt of court. You're not going to go to jail because they hit somebody, and you're not going to have to personally pay their debt. So I have an individual who owes a bank a lot of money. I'm the guardian, and he has had to be. He's older. He's a senior citizen, and he's had to be placed into. He has Alzheimer's, and we have money, and we placed him into a nursing home. Now I could pay his debt, or I could get him eligible for Medicaid and pay for the better facility and all that. Well, that's what I'm doing. I'm paying on his debt, but I'm also making decisions about what's the best situation, what should happen. In the end, the bank that he owes money to will lose a lot of money. They will never collect on it because he will soon be judgment proof because he'll be on Medicaid. That's okay. I'm acting in a representative capacity. I'm making decisions just like you and I do. When if you can't pay all your bills, you decide which ones to pay. Now, in theory, he could file bankruptcy. There'd actually be issues with that, but he could file bankruptcy. There's just no reason to because he's judgment proof. You can't collect against him. So eventually, the bank will just lose out, and that's the end of that. I'm not liable for that debt that he owes unless I intentionally mishandled the funds. again, right? So unless I stole them. But as long as I'm making decisions that are on behalf of the ward, then I'm fine. And if I sign paperwork, like I had to sign the paperwork into the facility to enter him in, saying that we would be that his guardianship would be financially responsible for his payments. I'm not, but the guardianship is that we will have the funds available to him. We will use to pay for his facility, right? So but I sign my name, Laura Drake, guardian. I don't sign Laura Drake. So, and those are the several ways that I'm acting as a representative. I am not acting as the guardian, and I'm not responsible for what they do. Now, in the DD system, you cannot be a provider and the guardian unless there is a blood or marriage relationship. And that's because guardians have to be able to freely advocate for their wards. And if they're being paid by the DD services, then that would be an issue, right? That's if I'm the guardian, but I work for the company that provides their housing, there might be a conflict of interest. So that's why that's happening. So now, you should ask the person that you're nominating, you know, and then, but again, remember what I said, they have to file in probate court. So, but that's why I like it when people name lots of people, because can go deep if people felt they had to say yes, or just things change, you know, parents name people when they're in their 50s or 60s, but then, you know, their 70s and 80s when things happen and they can't do it. People can't do it at that point. There is something called APSI, and that's a nonprofit agency for people who need a guardian but don't have one anymore. It's not the perfect situation. It's a stopgap, but they have a long waiting list. So that's why another thing, if you're naming a guardian, if you want to become guardian of your child, you need to realize this is going to be a lifelong endeavor, and you really need to think about who's going to handle that once you're gone, because your child has to have a guardianship. Once they've been deemed incompetent, unless the court says that they're cured, or doctors say that they're cured, then they're going to have to continue to have a guardianship. So the application process for guardianship is really not that hard. Every court has the forms on their website, and you do not have to hire an attorney to do it. Many people do hire an attorney because it's stressful and they aren't comfortable with the forms, and they're not sure what they're looking at, but you don't have to. And I know Miami County has social workers, caseworkers who will help you kind of review the paperwork and show you examples and things like that. There are little booklets that kind of talk about it. So, you know, but to start out, the first thing you need, the thing you have to have is you have to have a statement of expert evaluation, which means that a doctor has to sign off saying that your child needs guardianship. And that form is on the probate court's website, and it's called the Statement of Expert Evaluation. And I think it's Form 17. So that you give it to your doctor, they fill it out and sign it. That form can be no more than 3 months old when you file for guardianship. Check with your counties. Like, one county requires that they be typed. They will not accept a handwritten form, and the doctors never type them. So you get it, you have to type it up, send it back to them to sign, because they never do it. And lessons we've learned. So then you take that and the initial filing application, which is like next of kin, who's related to this person. Well, if you're the parents, you're the next of kin. You don't have to list their siblings. You're just going to list you and the parents. If the parents are gone, all the siblings have to be listed. So that's one of the things we have to know is who are the next of kin. And hey, we want to be guardian, and here's why. You take all those forms, the Statement of Expert Evaluation, and you go to the court and you file them along with the court costs. Then every court has an investigator who will then come out and meet with them. So, you know, a mistake we see happen is like, you know that your child goes to school every day from 9 till 3. The court investigator does not know that. So if you know when you file this form that your child is at this location from 9 to 3, you need to tell the court that, hey, by the way, from 9 a.m. to 3 p.m. on Monday through Friday, this is where you find them, at this address. Because if not, they'll keep coming to your house because that's the only address you gave them, and no one's home because you're at work and your child's at school, and then the whole thing falls apart. They have to start all over a little bit. So if you tell them where to go, the court investigator will come out and meet with them. They are very respectful. I've had families say, hey, I don't want them to say things that would make my child feel less about themselves. These men and women this is what they do. And they're just going to ask them questions and talk to them. And they have the statement of expert evaluation. So they should know from that, some individuals, they have a disability that they sound great for about 10, 15 minutes, and then it starts to be more obvious. And the statement of expert evaluation usually will say things like, they can't talk about, they don't understand money, but they understand this, or they don't understand time, whatever. And so the court investigators, go through that and figure that out. And they will file a report that is not sent to you. You don't see it until you go to court unless you ask for it. And then there's a hearing that's set. It is generally very informal. And the magistrate is there, and they will tell you if your child has to come. In some counties, like in Hamilton County, they don't. In Claremont County, they do. They absolutely have to be there. Montgomery County doesn't, they're not so specific. I don't think. Warren County, they don't have to be there. So it's all varied by county. Sorry, I can't remember them all. The ones that I have seen, in Claremont County with the magistrate, it's just the sweetest thing ever. He's very nice about it. And do you think your mom and dad will make the decisions for you? Do you trust them to care for you? There's no, they're not really asking whether or not they're competent, because we recognize that sometimes that is not what should be said in front of the individual. So usually it's usually very informal, and they chit chat. And then they'll make the decision. They'll usually tell you right then and there what they're going to do. Sometimes they'll take it under advisement. I would say if they take it under advisement, that's not a good sign. That means that there's something, maybe the court investigator doesn't agree. But if the court investigator really has concerns about it, the court might appoint that guardian ad litem that I talked about before, an attorney to represent your child. If they agree with the idea of guardianship, they'll issue the letters of guardianship. And that's it. That's the big paper that you need, that you're going to show to the hospital and to show to everybody else. Like, look, I have control, I have authority, I have these letters of guardianship. And then those are good. They're valid until they're not anymore. But that's it. They're ongoing. They're usually of an indeterminate time. And so they will last really forever is an overstatement, but close to it. And I always tell people, take a photo on your phone of it, scan a copy, and then you get a certified copy. Nobody should ever need that, except for courts and attorneys. And then you have just a paper copy, and hospitals and doctors, that's all they want. They're going to be fine with that. Same with the schools and everyone else. It's very rare anyone's asking for the certified copy outside of financial situations. So, and again, you don't have to have an attorney. That's up to you. Now, you have to sign an oath as guardian. And the number one thing you're saying is that you will act in the best interest of the ward. So you might think one thing and the ward thinks something else. You are supposed to take what they're saying into consideration, and then you can make a decision in their best interests. If the court issues you an order, you must follow it. The court is really in charge. You're just their agent. So counties vary. Butler County is now requiring an annual report. Most counties require a biennial. So every 2 years, if it's just guardianship of the person, so not the money, just guardianship of the person, you have to say, hey, here's where they live. They've seen a doctor in the last 12 months. This is what we're working on. Here's where they've made improvements. Here's where they haven't. When have you seen them? Now, if you're their parent, you see them all the time, but I'm a professional guardian. I don't actually do guardianship of the person, but so I don't see them as often. I might see them a few times a year, but I have to see them 4 times a year if I'm guardianship of the person. I don't do those though. But if you're, but you have to point out, so if your child lives in Denver, if they're doing a Zoom 4 times a year, that's great, that's enough. But they need to kind of know what's going on, that's the point. If the guardian child, the guardian who is your child is the guardian of your child who's the ward. So the one in Denver is the guardian for your child who lives here. They can just see them by Zoom. And this last year, that was really pretty common. But they have to file this report at least every 2 years saying this is what we've done. Now, if they're guardian of the estate, they have to file a report every year. And that's, here's all the money that came in. Here's all the money that went out, and here are all the court orders saying I could spend that money. It's a lot more complicated. So in the DD system, we are asking that the decisions that they made the best interest of the child, but also taking into consideration their needs, desires, and preferences. All right, and then the last, the other thing you have to do as the guardian is seek required training. In Miami County, I'm pretty sure it's requiring that now. So there is, here we go. The Supreme Court of Ohio offers guardianship training. Some counties do not require parents to take it. That's a mistake. You should take the training. I've had parents say they don't want to because it's really long, and it is, but it's still worth it. Especially if you're hiring an attorney, because this thing is going to answer so many of your questions. It will, and the training is free, and it will answer a million questions that you would have otherwise called up an attorney who would have turned on the clock and charged you for that time. So there's this initial 6-hour training, and then they have a bunch of 3-hour refresher courses. Now this is an old slide session, I realize, because it says in-person or online, and that's not true. There's no in-person training right now. I do think that'll come back, but right now there's no in-person. It's a video. You can watch it anytime you want, and you can stop it and start it back up again. If you're a professional guardian, everyone has to do that. I've been a professional guardian in Hamilton County for a long time, at least 6 years. And they just were like, hey, we don't have your 6-hour training certificate. I'm like, well, I did it. They're like, well, we know, because you do all the 3-hour ones. So I had to, but even I couldn't find it actually, which was weird. So anyway, they found it for me and we had to file that. But as a family member, you usually don't have to do it, but I would strongly recommend it. If you're even thinking about doing guardianship, you should watch this. And the 6-hour one does not expire. I mean, none of them expire, but if you're a guardian, you have to do so many every year, so there's no reason to get ahead. But the 6-hour one does not expire, and I'd really strongly recommend you watch it. It's a really good overview. Obviously it's significantly more in depth than what we're doing here. It's about your obligations and rights as a guardian, and it's a really good training session. So this slide's irrelevant right now, but Montgomery County has offered in-person screening in the past, in-person training in the past. So is Butler and Clark. So you have some near you that will probably come back and offer that again in the future. But I would just say do the online one for now. So, if you want to be a great guardian, not just a good guardian, you want to see your ward often. That's important. You want to ask for their opinions and advocate for them. All of that stuff is, so Mary did ask if Miami County requires the course. I believe Miami County does require the course. I have one in Greene and Miami County pending right now, and I know it's one of the two that requires it and the other one doesn't, but I'm pretty sure it is Miami County that requires the course for everyone. But even if they didn't, you should totally take it because it's really good. You need to see the ward often. And again, nowadays that can oftentimes be via Zoom. You need to talk, you need to ask their opinion about what they want, and you should take it into consideration, and then you need to be their advocate. So they might not, what was I? Oh, so my nephew's at Ohio State, and he hated his dorm. It was 16 guys in 4 rooms, in 5 rooms. It was absurd. And I was like, you have to go and apply to move someplace else. And then he was like, I'm not sure. And my point was, yeah, you're an adult. If you don't do it, that's on you. Live with the 16 guys and the horror that you live in. But the difference is when you're their guardian, you have to take the steps to advocate on their behalf. You have to still act in that parental manner because they can't do it themselves. So that's something to think about. I've done something. There we go. You cannot delegate a responsibility through a power of attorney. So if you are the guardian and you're going to Costa Rica for 2 months, that's fine. But either you're going to make yourself available or you're going to have a temporary caregiver or an interim guardian. So you're going to leave the country for a couple months, but your oldest child isn't, and neither is the ward. You're going to sit there and say, hey, oldest child's going to be the interim guardian during those 2 months. All right. And the court can approve that. Otherwise, you can sign a consent to treat form And then also in this day and age, they can scan stuff to you, they can email things, you can sign it, take a photo and send it back. But if you're going to be unavailable, you need to notify the court about a temporary caregiver, and that's fine. They'll take care of that because you can't delegate it otherwise. Now, if you want, as a guardian, there are other things you can do. You can open a stable account. You can also create some trusts with the ward's assets. Usually, you need the court to approve those things. So as I'm guardian of the person, I don't have any control over their finances, but most courts around Ohio understand what these pooled trusts and stable accounts are, and they will give you limited guardianship to set those accounts up and then walk away from. So you're not the guardianship of the estate, but the court will give you power to do this. I had a client who I wasn't the guardian, his mother was the guardian, but he was a beneficiary of a trust. I mean, he was like, if his dad died before he was a certain age, then this kid got some money. I mean, you know, and it was pretty unlikely because the dad was healthy and he was not that far away, but for tax reasons, they wanted to shut down this other trust and fees and all sorts of stuff. And so the court approved mom to sign off on the consent to terminate the trust. All right. So even though she wasn't the financial guardian, once we explained to the court what was going on, the court agreed and gave the guardianship gave her authority to sign off on that, so the trustee would shut it down. So you can do those things. You just want to make sure they're limited and short term, so you're not stuck as guardianship of the finances. All right. So what is it? I've said it a couple times. What you have to make a decision in the best interest of the ward. What does that mean? Well, you know, what would a reasonable person in that position do? And the reality of it is, we all know this, in the last 4 years, we've seen it more than ever. Reasonable people disagree on stuff, but you still have to think about what they would do, so long as it won't cause them harm or be against a court order. All right. So your number one goals, you have to keep them the word safe, nourished, and healthy. That's why they ask about have you been to the doctor? And then beyond that, can you do what the ward would want you to do, or what the ward would want to do if they were left to make a decision, if that decision wouldn't be a bad idea? And that's ultimately what the guardian is. They're the one who makes the decision. That's a good idea. That's not a good idea. That's your job. Now, what if you're the ward and you hate your guardian and you want a new guardian? Well, you have to file something with the court, and the ward has to file something with the court. They should have the court should have the probate court investigator investigate. There may be a hearing, and they may need a motion. It's very hard to remove a guardian, especially if it's a family member. Courts are not crazy about changing guardians. The ward has the right to go to legal aid and ask for assistance, but the court should actually appoint an attorney to represent them. So they should not have to have an attorney. But if they need one, they should start with legal aid, who might at least get them to the court to the point where they can ask the court to appoint an attorney. The court should appoint an attorney to represent the ward. Now, the county board of DD, they really can't do much with guardianships anymore. They used to have a lot more control and say, hey, this is a bad guardian, this is a good guardian. The court in 2010, the Supreme Court said, yeah, we're not going to do that so much. The board can give information to the court, and they can provide protective services, but they have to provide regular services and maybe protective services, but their role has been limited unless the guardian is asking for more involvement. All right, how do you terminate a guardianship? Well, there has to be a clear improvement of the ward's condition. And that's why, again, start with these less restrictive forms. There's either a limited guardianship for a specific purpose. I need to enroll them in this school and they won't let me. Okay, then just become guardian to do that. But also look at, can they sign the financial power of attorney? Can they sign the healthcare power of attorney? Once a year, the ward has the right to ask to end the guardianship, and the guardian just has to show that the guardianship should go on, but they tend to. Now, this is weird. It used to be that you oftentimes started a guardianship so that your disabled child couldn't get married, but marriage is a fundamental right. Courts in Ohio are kind of split on this, but generally if your ward goes out and gets married, the guardianship is over. So, which is weird. In other states, it doesn't work that way, but currently in Ohio, that's kind of the trend. It depends a lot on the court. There's a case in Claremont County not too long ago. The person went out and got married, guardianship's over, the marriage is valid. Because again, it's a fundamental right. So you'd have to show, but now if you could show abuse by one of the parties, like or undue influence into forcing them into marriage, that's different. But if they're saying it's their voluntary decision, then the courts are usually going to terminate the guardianship on that. Because if they can make that decision, then they can make other decisions. So again, in DD services, that other less restrictive way is to have the chosen representative. It's a form that you can get from your DD caseworker, and that authorizes you to make a decision on their behalf. That has to be in writing, but again, if they can't sign their name, they can put an X. There's a mechanism, there's language where they say, someone witnesses and says, I saw them sign their X. And you can name your chosen representative, the child can, and they can also revoke it. So they can terminate any of those things. We presume people are competent until a guardian has been appointed. Until the court has determined them to be incompetent, they are competent. Now, it doesn't mean they're making the best decisions, and that's why the family members can provide that supported decision-making and guidance so that they help them make the right decision. I have a friend who had a daughter with Down syndrome, and they never had gotten guardianship because they never felt any need to. And she was in her mid-30s and she fell and she broke her arm. There was no bone protruding. She's, ow, but she was not bleeding. There was nothing like that happening. They go to the emergency room and they explain to her what would need to happen. And they said, are you okay with us resetting your bone? And she goes, no, I'm not okay. I don't want you to. That sounds like it's going to hurt. I don't want to do it. And the parents were kind of taken aback because, they'd never had that happen before. And in that situation, now, the recommendation is really you just go and get that limited emergency guardianship or temporary guardianship. And she did get that. They didn't make anyone show up. The doctors filed the paperwork. They went to court. The inspector came out and met with the girl with her broken arm, and they signed off on it. And she was back at the hospital the same afternoon with this emergency temporary guardianship. But then after the period was over, they did extend it they converted it to a guardianship of the person. But that was a situation where they could not make, no matter what they did, they could not make her see that there would be a benefit to this medical treatment. And when that happens, you're sometimes forced into guardianship. I always say, if you say day and they say night, and you say moon and they say sun, you might have a problem with the idea without guardianship. But if they're 18 and they're kind of in that rebellious teenager years, that doesn't necessarily mean you need guardianship. If they're still in that rebellious teenage year, when they're 26, maybe you do need guardianship. Those are decisions that family members have to make, but they're presumed competent until you go to court and get them determined to be incompetent. But no matter what, these people have the right to participate in the decisions that affect their lives. All right, and so you have to make these decisions always as guardian or chosen representative or anything else with the best interest in them, consistent with their needs, desires, and preferences. And that's always something that you have to be keeping in mind. If you're not the family member, but even if you are, you need to make sure you're most aware about their lifestyle and their preferences and what their values and beliefs are to make their decisions. What decision would they have made if they were capable of making the decision? That has to be what's in the back of your mind. And that's what your goal is and role is. So guardianship should not be chosen as an option. We used to see this a lot more as a method of controlling the child. So, the larger the circle of support is, the easier it is for the individual to make decisions for themselves. So always reaching out and trying to expand that circle is so important. All right, now, like I said, the probate court has lots of training programs that's run through the Supreme Court. Disability Rights Ohio has a book about guardianship. The Ohio DD Council, I don't think it's up here, they have a guardianship booklet also. All the Midwest Care Alliance has all the advanced directive forms, and the Ohio Attorney General has a guardianship guide. So, and this is just for educational purposes. All right. So does anyone have any questions for me? I'm gonna stop sharing. About guardianship. I'm also gonna take a drink. As I was telling Melissa, this is Fiji water and it's amazing.
If you have guardianship and you are going to change residents of the ward, how do you let the court know? In that training, they said I had to notify them, but I don't know how to let them know.
So there is a change of address form. Most counties, that's all you do. You file a change of address, and that's how you let them know. So we just moved somebody from Hamilton County to Holmes County. So we switched. I mean, we went the other side of the state, and now there we called the magistrate and talked to him about it. But you just file a piece of paperwork, like they live there now. Now the difference is, except in that situation, he was in a facility and we moved him to another facility. If he was independent and then we were moving him into a facility, the court has to know about that and approve being placed in a more restrictive environment. Does that make sense?
She's actually going backwards. I'm her sister and her guardian, and she's been living in a house in Troy where an agency came in and provided 24/7 care. Because of the pandemic, I left my job and I took her into my house, and because of staffing, she's staying. So now she's permanently moving into our house, and it's not a temporary move anymore. It's permanent.
Yeah, it should be. If you can't find the form, just email Melissa. She'll send it to me. I'll send you the form. But it is literally just a change of address form. You don't need the court's approval for that.
Do I have to let them know that I'm going to become her OSL also?
So guardians of the person, there's whole things about being paid by her. If you're being paid by the county, that's different. But if you're using her money to pay you for services, yes, the court has to approve that.
No, it's the waiver that's going to pay me.
Right. Yeah. So the money's coming from the county. I don't think the court cares. It's just you can't use the ward's money to pay you.
Okay. Yes, it won't be. Okay. Thank you.
Yeah. Do we have any other questions? But I will say you can always ask the magistrate. That they'll tell you pretty quickly if they need more from you. So. Ellis, do you have a question?
Yes. We had applied for guardianship through the court in Montana for our son who has Down syndrome. Nothing has changed in his situation. Are those guardianship papers legal in other states besides Montana?
If you're still residents of Montana, they are, but if you're not, then no, because that court doesn't have any jurisdiction over your child anymore because they're not a resident of Montana. But you could take that paperwork and you would contact the court here and there, and the Montana court should send the paperwork to the Ohio court, and then the guardianship would be transferred. But if you're, let's say, so Montana is still your state of residence, and this happens a lot in the Montgomery County area, in that area. You're here with the right pat, but technically Montana is still your state of residence. You're just here temporarily. Then that paperwork would still be valid. But if you're here as long, you're really technically now an Ohio resident and you don't intend to return anytime soon, maybe you'll retire to Montana, but it's not where you vote, it's not your residence, then you need to transfer the guardianship here. And you have to terminate the one in Montana because you have to tell them you don't live there anymore. You have to give them notice of where the ward is. But the easiest thing would be to transfer it to Ohio. And they'll take it. It's not a big deal. It's pretty easy, actually. There's like a form you fill out. You start one and then you transfer. They send an exemplified copy of everything. It's kind of annoying, but it's not that bad. And then they reissue the letters of authority from the Ohio courts.
I see. Okay, I'll have to see if I can get that done then. Thank you.
Yeah, and they'll work with you. They're pretty easy about it. So, any other questions? Can I just say I am so excited that my dogs have not barked. They have come in twice and run to look at the windows. That's why the blinds are shut. Now it's dark, but they were shut pretty early because the dogs like to bark at whatever passes out in front of the house. And I was like, no. It worked.
Does anyone else have any additional questions? If you don't, and you think of something you'd like to ask later, I've got information to share with you, Laura's email address, and we also will have this presentation I can send out to you via email. If you want to look over it again, you can look back over the slides with a lot of that information. I know it's a lot to take in and process as it's going by, so a lot of times it's helpful to look over it afterward as well.
Yeah, and seriously, if you have questions about it, just feel free to reach out. It's not a problem. And then if you're over the age of 60, not the ward, but if you're over the age of 60, you can also contact Pro Seniors and they give free legal advice also. So for your, even though it's really about your 26-year-old kid, that doesn't, you're the one asking for advice. They'll give you that. If you're over 60, they'll give you that. So something to keep in the back of your mind.
I have a question.
Sure.
And I may have missed this. Now, if something were to happen to, is there a way to set it up so that if something happens to me, that you appoint someone else as her guardian, or how does that work?
So something happens to you. So like I said, if you wanted to, you could, in your will or health or financial power of attorney, you can say who you want to be your child's guardian after you pass away. But if you're the guardian and something happens to you, somebody else has to apply to become the guardian. So
Okay.
So your spouse,
I did hear the end of that. So
yeah. So they have to apply. So
Okay.
your spouse or your children's siblings would have the first crack at it. Then your siblings and aunts and uncles, kind of the family. But a non-family member can absolutely apply. They just have to give notice to the family, and it's up to the family to say, no, I want it, or they don't step forward. Then the non-family member can be. But remember, if they live out of state, any of those siblings or relatives you would want to be a guardian, you have to name them in a financial power of attorney or a will that those are people you would want to be your child's guardian.
Okay, thank you.
Of course.
Yes, Laura, you had mentioned if somebody was over 60, they could get assistance somewhere.
Yeah, Pro Seniors, I can actually give you the number because I know it by heart. It's 1-800-488-6070. You can call them and they'll schedule an online, a telephone appointment with an attorney. Yep.
Okay.
And then, it won't be that day, but they'll schedule one and you can talk to an attorney and they'll give you legal advice. So.
All right. Well, thank you.
You're very welcome.
Very helpful information, Laura. Thank you so much.
Hey, I have to admit that I actually help Pro Seniors on their hotline, but not much. So every once in a while, whenever I get a call that I'm like, I don't know, why don't you call Pro Seniors?
Oh, shoot. All right, going once, going twice. Any last questions? All right, well, with that, I'd like to say thank you again to Laura Drake for coming and spending time with us tonight.
Well, thanks to everyone who came and joined us. I appreciate you guys listening. And like I said, if you have follow-up questions, please reach out. All
right. And I stuck my email address in the chat. Again, it's melissa.nichols, that's NICHOLS, at riversidedd.org. If you would like to have a copy of this, a PDF file of the PowerPoint presentation, just send me an email and I will send that out later this week. So look forward to hearing from lots of you, and thank you again for joining us.
Thanks so much. Have a nice night, everybody.
Bye-bye.
Bye.